Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Where are we today? Well, hey, just because we got a new studio doesn't mean we don't want to come over and hang out with all the cool people. So that's right, we are at Washington's premier indoor shooting facility. Of course, that is Security Gun Club right here in Woodinville, Washington, Illinois. We get to talk again. And, listen, I get that. First of all, I appreciate all of the support that everyone out in Illinois has shown Washington Gun Law. We love all of you. Thank you very much. And I really appreciate the support because I don't often come on and give you all a bunch of good news. In fact, it usually is somewhere between, are you going to get kicked in the nuts or punched in the mouth today? You got a big, huge trial coming up next week. It has to deal with your assault weapon ban. I think in many ways we can probably predict what's going to happen here, but there has been some developments and I think you need to be aware of it because this is big stuff that's coming up next week, Illinois. So today, let's spend a few minutes, let's get you educated, and let's talk about the huge assault weapon battle coming in Illinois. Why in the year 2024 should anybody even think about having self-defense protection? Because, 25 years ago, we would have never had this conversation. So what's different today?
Bill, we really saw a need a number of years ago when the volatility and divisiveness of our country started to change drastically. And we, by the way, are gun people protecting gun people. We come from a significant gun background.
Right to bear, that's right. Legal protection for self-protection. Listen, good lawyers aren't cheap. Cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, this is what we are talking about. We're talking about the case of Barnett v. Raoul. Now, we have talked about that case, and there are other cases that are consolidated with it. We're going to mention a couple of them here. The other one is Harold v. Raoul. And then there's a third case, the Langley case, which is actually going to be the subject of some of the things that we're going to talk about on this video. Now, for those of you who've been geeking out on this issue, you will know that all of these cases are a challenge to the Protect Illinois Communities Act, or what we like to call here at Washington Gun Law, the absolute most unconstitutional piece of civilian disarmament legislation ever passed in the history of the United States. Not only what it did, but how the state of Illinois did it to its residents will long, long live in infamy. Now, Illinois, this is filed down in the Southern District of Illinois, and let us not forget that you actually have enjoyed some success from that jurisdiction. In fact, there was a preliminary injunction that was granted against implementation of PICA, only, of course, to have the Seventh Circuit swoop in and suck it all up and destroy it from there. And, of course, that will be one of the underlying themes of this, is let us not forget that looming overhead is, in fact, the Seventh Circuit. Okay, now, here is one of the big developments, Illinois, is that these suits, all of the consolidated cases, will only be proceeding under Second Amendment and 14th Amendment arguments. Any of the other arguments have now all been dismissed, most via summary judgment. The latest is a Fifth Amendment challenge that was brought in the matter of what some people are calling Langley v. Raoul. I actually think the title is Langley v. Kelly. It's irrelevant. It's the Langley case. And listen, I thought the argument was a good argument. We even did this video right here about it, where we said, hey, listen, is there a Fifth Amendment implication here? Because now you've banned these weapons, and now you're telling individuals that you must disclose in writing to the state that you possess a now banned weapon and exactly where they could find it. And it does shock the conscience when you read about the right against self-incrimination. Now, the trial court here, however, was not convinced and has thrown that challenge out on summary judgment. As a matter of fact, the court here has specifically ruled at this stage the Langley plaintiffs have failed to advance any arguments that indicate the PICA mandated registration requirement has in fact led to unconstitutional self-incrimination in violation of the Fifth Amendment. late registration does not carry criminal penalties in accordance with PICA and the administrative rules. They do not argue that any specific individual or that any of the named plaintiffs have been subjected to self-incrimination in violation of the 5th and 14th Amendments. In fact, they do not dispute any of the material facts in question, as Director Kelly has indicated. Because there are no genuine issues of material fact in dispute, summary judgment is therefore appropriate. I get that some of you may think that this is a terrible ruling, and that certainly is your prerogative, but I want you to understand that the judge here, Judge McGlynn, we have had previous success because this is the judge that previously granted the temporary injunctions against PICA. So he has heard many of the core arguments that will be argued once again. Now, let us also not forget, though, that in the meantime, the 7th Circuit in interlocutory appeals up there has ruled, and this, I know many of you better be sitting down for this, that the Second Amendment does not even cover semi-automatic rifles. That's right. Let me say that again. The 7th Circuit has ruled that America's most popular sporting rifle is not even protected by the Second Amendment. Now, why would the court actually rule that way? Well, we know that if the Second Amendment is in fact implicated, which by the way it is in this case, well then the Illinois state government's going to have to justify this ban through some type of historical analogs. Since nothing really exists that could even come remotely close to justifying this, they would lose. For that reason, the 7th Circuit says, well, you know what? You don't even have to worry about history because the Second Amendment is not even in play here. Now, many of you may be worried, but wait a second. Doesn't the judge then have to follow that authority from the 7th Circuit? Au contraire, he does not, and here's why. Those rulings were all in relation to whether or not the court had abused its discretion in staying the injunction. So remember, the trial court, we had an injunction. Then the 7th Circuit stepped in, stayed that injunction. In deciding that the stay was appropriate, that's where the court made that finding. So, Judge McGlynn is certainly not bound by that authority as it was not a final ruling on the merits. Now, we know the state of Illinois is going to be pounding on it like a bass drum and saying over and over and over, this isn't even a Second Amendment case. This isn't even a Second Amendment case. Do I believe that Judge McGlynn is going to fall for that? No, I don't. I think he's a much more intelligent judge than that. So here's our prediction. And the prediction can really be summed up in these 4 words. Win, stay, appeal, lose. So Washington Gun Law's prediction is, at the trial court level, the plaintiffs are gonna prevail. In fact, Judge McGlynn is going to find that this law is in fact unconstitutional in violation of the 2nd and 14th Amendment. There will either be an administrative stay issued by the judge, or the state of Illinois will immediately crap its pants, ask for one from the 7th Circuit, they will get it. Then the matter will be appealed. Then the 7th Circuit's gonna get their hooks into it and they're gonna flip it. And so for that reason, when you take a look at the 4 things that are likely going to happen, once again, we believe it will be win, stay, appeal, lose. So, is this the light at the end of the tunnel, Illinois? No, not based on these cases. Unfortunately, no. I think there's still a lot of darkness left ahead of you. As a matter of fact, the light at the end of the tunnel for any of us really now comes out of Maryland. And when you take a look at where the Bianchi case is out of Maryland, which is completely done, there is nowhere else for that case to go. And it is already on petition for certiorari to the United States Supreme Court. That case has clearly moved into pole position as to the first assault weapon ban case that could be accepted by the United States Supreme Court. So for those of you living under one of these unconstitutional pieces of legislation, you will need to keep your fingers crossed. Okay, the case once again is Barnett v. Raoul. There are several other cases consolidated with it. We'll link them all up down below so that you guys can geek out on it for yourself. Trial is set for early next week, Illinois, so obviously we will be following up with additional videos. If you got any other questions about this or anything else related to what's left of your Second Amendment rights, you should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information, it's down there in the description box. Maybe you got an idea for a video we should be doing around here. If you do, click on that link right there. Let us know. Your idea is probably better than anything we're going to come up with. Maybe you just want to be part of our monthly newsletter. The ability to subscribe and do all of that is down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.